Good afternoon, financial professionals. Abby Fletcher here of E4 Insurance Services, welcoming you to the BREW, Building Relationships Every Week. Thanks for tuning in today. For those of you joining the BREWcast for the first time, we like to start by celebrating today's National Day for February 10th. Today is National Umbrella Day. Not only does the umbrella keep us dry from the rain and protect us from the sun, but is also a fashion accessory for our drinks. We can credit the Chinese for this invention, as their paper parasols received a layer of wax and lacquer, which made the umbrella able to withstand the elements. Fun fact, the word umbrella comes from the Latin word umbra, meaning shade or shadow. Today, give your umbrella a twirl. Today on the BREW, we have Eric Christoffersen, who is an estate and business attorney, who is not only our friend, but a highly respected resource in the estate planning community. Eric serves as practicing attorney and managing shareholder at Grams Christoffersen, which has many locations throughout greater Wisconsin. This BREWcast is a two-part series titled Trusts Uncovered. Eric will share the many trusts available for our use, highlighting their many benefits and the proper ways to implement these various trusts. Take a look at the chat box below. I'll be keeping a lookout for these questions as Eric is live. Also, the entire audience is in a drawing for a free continuing education course, and we'll be announcing the winner shortly. This BREWcast is a two-part series, so be sure to check out the first and second editions. Thanks for tuning in, and without further ado, welcome, Eric. The mic is yours.
Thanks, Abby. Really excited to be here. Been on the BREW before, but I really like the method and everything that you guys do here to help encourage and develop professional advisors. Something that I feel very strongly about as an attorney is that one of my jobs is to get out into the community of other professional advisors and help them understand what I do with clients and help them better communicate to their own clients. Since oftentimes the financial advisors are the boots on the ground. They're the ones that are getting out there, meeting with the clients, really getting in front of them, finding out about what their needs are. So I have the utmost respect for that profession and for the work that all of you do. And so I view myself as the attorney as a tool to help you serve your clients, rather than the other way around, where somehow I'm trying to come in and, take over a relationship that you've developed over a lifetime. So that's just a little bit about my philosophy for those of you who don't know me. But I'm excited to be here, and like you said, here live to talk about Trust Uncovered. So very apropos the umbrella thing, because the trust is like your umbrella. It's going to protect you, and today we're going to uncover it, meaning pull it back, learn a little bit about how that works. So I do have some materials here that I'm going to share. And so first off is just an introduction to me. Don't want to spend too much time on this, but just so that that I'm speaking on this topic coming from a position of authority and someone who's worked in this area extensively. I've been practicing for 11 years exclusively in trust and estates and business law. We operate primarily in Dane County, but all over the state of Wisconsin, and we do have clients outside of the state as well. And the key thing with our firm is, again, we specialize exclusively in estate planning and business. So we are a specialty firm, and I'm the second generation owner of that firm, and I lead a great team of people here who do a terrific job, serving our clients. But also, as I said, I like to get out there and be a speaker to the community, but especially to professional organizations of other professional advisors. So very excited to be here today. And this is just a little snapshot of the great team of people that I work with here who help serve all of our clients. So moving on specifically to our topic of Trust Uncovered. So this week, we want to give you some groundwork, lay the foundation for next week, when we'll be able to talk about some more complex advanced strategies as well. So the way I do these podcasts too is I like to target so that it will be helpful even for a new advisor just learning the ropes, but at the same time, we want to have it be advanced and in-depth enough that even an experienced advisor will find value in the materials that we're presenting. So we really try to keep all of that in mind when we're presenting. So today will be more on the general side, but even among that, I want to try to really just hone in on specifically what we're talking about, so that as we get into specific trust strategies, you have the right lens that you're looking at those strategies in, meaning who is this strategy for? What does it accomplish? When should this be used? Some of those basic high level questions really are the good starting point to start out with. So this week I want to just give you a little primer, trust in general, and then specifically talking about revocable trust. We won't spend a whole lot of time on that because, again, that's more of a basic concept that we want to introduce. But for the audience here, many of you are probably familiar with that already, and we want to make sure we're providing some more advanced value. And then specifically, the third topic today is just talking about the different types of trust that our clients can set up for their beneficiaries. And so that's just a category in general, beneficiaries trust, and we'll talk a little bit within that category about a couple different strategies. And then next week, looking forward to talking about some more advanced strategies that are going to be involving either estate taxes, life insurance, charitable planning, some of those more exciting, more robust topics. I'll be looking forward to finishing off the two-parter with those next week. But like I said, laying the groundwork this week to be able to do that. So the very first thing that you want to consider whenever you're talking about trust is, well, what type of trust am I talking about? And all trusts are going to fall into these two categories. The two categories largely being, can this be changed? Is it a revocable trust or an irrevocable trust? Again, the general idea being revocable can be changed, irrevocable cannot. But again, anyone who knows me I'm always very specific to say, even within the irrevocable trust that we build, the ones that supposedly cannot be changed, we build in tremendous amounts of flexibility for our clients to be able to change a lot of components within that trust. Even though the entire arrangement may be irrevocable, there's still going to be a lot of flexibility. But that's a side point. But in general, can it be changed? Yes or no? And in general, when is this trust being funded, or when is it actually coming into effect? Because we as estate planning attorneys obviously are putting on paper in a document trusts all the time. But the big question is, that trust that I just wrote into this document, is this trust effective immediately, or inter vivos, or created during your lifetime? Or is this trust actually not going to come into effect until after the client dies, as what's called a testamentary trust, a trust that comes into play at death after the client has already died? Like I said, it may be existing in their planning documents right now, but it doesn't exist in the sense that it hasn't been created with an EIN, it hasn't received assets yet, or hasn't been funded. So when is it created? When is it funded? Kind of interchangeable terminology there, but that's kind of the second component. So, you can have revocable living trusts. You can have irrevocable testamentary trusts. You can have irrevocable inter vivos trusts. So a lot of times, when first question, even before you analyze what specific type of trust is, what general type of trust am I talking about? Does this exist right now? And is it revocable or not? Those are really the first big questions. And when we talk about our other strategies, we'll try to always go back to this and say, is this existing right now? And is it revocable? Those are key questions that you want to know when you're looking at a trust, or when you're talking to a client about a trust, where they say, hey, I have this trust. A lot of times it's, okay, well, you have it. Again, is it on paper, or is it something that you're going to have in the future for your beneficiaries? It's just very important to know the context, especially when you're dealing with financial instruments, whether that's titled into a trust, whether the trust is being named as beneficiary of that asset. Important to know kind of the ground rules of what is this trust that is interacting with whatever financial instrument, whether it's a life insurance policy, a retirement plan, an annuity, whatever that might be. So the next slide then is just talking about in general, what's the purpose of creating a trust? And really, it's going to fall under what I like to say is these three general purposes: efficiency, privacy, and protection. You're probably after one or all or many of these things when you're creating a trust agreement. And so, the efficiency and the privacy, those kind of go without saying that, okay, by having a trust, it's going to be more efficient because it's not going to be subject to a probate court system. It's going to be privately administered by your family, the private part. And so it's really just keeping it out of the realms that it shouldn't be in, whether that realm is a probate court, whether that realm is beneficiaries that you don't want to be involved in your estate, whether that realm is creditors, whether that's the IRS, just keeping things private and keeping things protected. And that's the bigger part, is not just that people don't know about it, but even if they did find out about it, it still is protected. And so that's really the key part ultimately, is, the trust is providing the protection. It's that umbrella that's sheltering you from whatever all these risks are. And so I didn't even know this when I created this slide, but I did create this as a cloud. Could think of it as a rain cloud here raining down on you. But these are all the different things that we create trusts for. And so it's kind of, shown as this is like, whoa, sometimes there's this big cloud of uncertainty, a big cloud of threats where any of these things could rain down on any particular client. So it's really almost about, when you're entering an individual client relationship, is analyzing for this particular client, which of these things in this rain cloud are going to possibly negatively affect them. Some of them you probably can take off the table and say, you know what, this doesn't apply to this particular client, so I don't need to worry about that. Again, we don't need to design and craft protection and protective strategies around things that we know the client's not going to face. But what you want to do is identify among this cloud the top concerns of the client. What are they worried about? And basically going from there, once you've identified the worry and the concern, that's when you can start to craft a strategy around how are we going to protect against that worry or that concern. So, some of these, as you see, have to do with taxes, whether it's income tax savings, whether it's estate taxes. Some of them have to do with qualifying for benefits. Is it a special needs beneficiary who needs protection from disqualification from public benefits? Is it a elder who is worried about, losing their hard-earned money to long-term care costs? Or then sometimes it's just, I'm worried about, creditors, or I'm a professional practitioner, I'm worried about malpractice, or, my relationship is on the rocks, or my kid's relationship is on the rocks, and I'm worried about what if one of those parties gets divorced and suddenly my assets are being divided in a way that I don't want them to. And then ultimately, kind of what we're going to talk about today too, is just beneficiaries and what is the life circumstances of your beneficiaries, and taking that into consideration when you design the trust for the client, so that you're not only just looking at what are the client's concerns, you're looking at what is their family's concerns, what's the concerns that they have for their beneficiaries. Because ultimately that's going to even deepen the relationship with your client, because many of your clients, you may have already set up, the protection that they feel pretty well protected, and that their retirement is secure, and if something happened to them, that they'd be all right. But a lot of times it's, well, what protection have you set up for your children and for your grandchildren? And are they all protected? And so it opens up some nice avenues of conversation, not just from a legal perspective, but also from a financial planning perspective and an insurance planning perspective, making sure that all of those needs are being addressed across the board for all stages of life. And that's what the trust is really nice, because it does open up and expand that conversation into those other levels that, that may not normally get talked about on the surface. So that's kind of the threats page, if you will. These are the different things that we may design a trust strategy around, saying, okay, now that we know that this is the threat, how do we protect it? What are we going to specifically design to stop that threat from affecting our client? So the revocable living trust, as I said, I'm not going to spend a lot of time on it, but this is the first strategy that every financial advisor is going to want to be familiar with. Most of you probably already are. The big benefit of a revocable living trust is twofold. And the first one is again, generally well known that, okay, this is a private family entity that will avoid the court system. Well, that is a huge benefit, and not trying to decry or belittle that benefit, but oftentimes attorneys who don't specialize in trusts and kind of do this on the side will just stop there and say, well, yeah, this is, why do you have a trust? Well, you have a trust to avoid probate. Well, smart financial advisors know there's other ways to avoid probate. A trust is not the only way. You can have beneficiary designations. Where a trust really shines is its ability to provide ongoing protection. And that's where, too, in my industry, I get involved in educating people all the time, where sometimes they think a trust is a trust is a trust. And, oh, I already have a revocable trust, or so-and-so did a revocable trust, and it's, very, very straightforward, very inexpensive. And it's like, well, that's probably because all that trust did was avoid probate, which, like I said, then that's not giving you really any additional benefit beyond just what a standard beneficiary designation could give you. Where the trust really shines is its ability. The second point here is that it can provide other benefits depending on the desires of the client. So that's where, again, this isn't a one-size-fits-all machine that says, okay, this is just here to avoid probate. What it's really here for is point number 2 would be best described as that protection. We're going to avoid probate, but we're also going to protect against whatever item or items in that cloud of threats that the client is worried about. Oftentimes it's concerns with their beneficiaries, and it's multi-generational legacy planning and some of those things. But the bottom line is you can build into a revocable trust whatever beneficiary trust protection that you and your clients want to have. But it's a matter of actually having that conversation about what are the needs and what are we going to do to meet those needs. And again, this is a fantastic conversation for you guys to get involved in, because oftentimes those needs may be legal in nature, but also financial in nature. Okay, well, how are we going to fund, or how are we going to provide financial resources to carry out these wishes? And so that's really where I like to help educate and empower financial advisors to really get involved and say, okay, now that we know what the client's concerns are, and now that we're building a strategy, let's work together to build a strategy that is both legal and financial in nature, and get both professionals working for you as a team and coming up with that great plan that's going to be a win-win for the client, for the attorney, for the financial advisor, and setting up that lifelong relationship, that team of people to take care of the client, and even beyond to the client's children, grandchildren. So the final topic here then that I want to talk about specifically is those trusts that you can build in to your revocable trust to protect your beneficiaries. And so I've got it listed generally in 3 categories. Of course, there's more than this. We're just on the surface here, uncovering some of the basic strategies that we could use here. But in general, these are the segments we look for to say, well, a trust is going to be structured drastically differently for each of these 3 segments of person. So the first one, again, that's the one that most people are pretty familiar with when it comes to trust planning, where it says, okay, I want to structure a trust because my kids are minors, and I want to wait until they receive assets when they're older and more responsible. So, you might say, instead of them receiving 100% when they turn 18, I want to structure it so that they receive, half their inheritance when they turn 25 and half when they turn 30, or, a third when they turn 25, a third when they turn 30, and a third when they turn 35. I'm just rattling off some structures and some numbers, but really the point is you don't want to have minors inherit assets directly, of course, and also you don't want to have minors inherit their whole inheritance when they become an adult 100% at age 18. So some of this is pretty standard advisement that you want to be giving to any of your clients who have minor children, or even any of your grandparents who want to be involving their grandchildren in their financial planning in some sort of gifting capacity or some sort of inheriting capacity. You want to make sure that that gift or that inheritance is received properly, so as that it's structured so that they get access to it at the right time. And then it's a matter of until that time comes, what are the rules, who's going to be in charge of it for them, and all of that. And that's what we help clients build out. And then, of course, the other concern that I'm sure you've heard of is, okay, my one adult child is not doing well for whatever reason, and if I were to leave them money, they would end up just spending it, and I need someone to help them, ration it out, for lack of a better word, so that they can use the money more responsibly over a longer term of years, rather than just spending all the money immediately. The statistics are that an average inheritance, the lifespan of the average inheritance is only 6 months. So that's how quickly people receive money and then immediately spend it. And so that's something that our clients, even who have adult beneficiaries who may not have the best dealings with money, that's a strategy that they would use even for adult, what we call less responsible beneficiaries. Now, I'm going to skip to the third one now, because it dovetails with what I was just talking about, the third point on this slide, which is adult responsible beneficiaries. We have a very unique structure for our adult responsible beneficiaries that we've set up at our firm, and how we do all of our trusts. And it's something that, we're very pleased with. Our clients are ecstatic to find out that this is an option for them. And that is that adult responsible beneficiaries. So when you meet with the client and they say, you know what, I don't need trust protection because all my children are doing fine. They're all happily married. They all have good jobs. I don't have any concerns about their ability to use money. I think they'd be responsible with it. Then, the answer is, okay, that's great, because we have a special trust just for those people. And honestly, that tends to be a majority even of the clients that we work with is tell that picture to us. And so this is where we've developed at my firm what we call our signature inheritance protection trust. You could call it by many names, but that's what we call it, is an inheritance protection trust. The idea is that you leave that adult responsible child the money in a trust, but you make them their own trustee. So the key point here is, because it's in a trust, it's still protected from all of those risks, whether it's a creditor, whether it's a divorce, whether it's the fact that the child is married and you, the client, want the asset to pass to that client's, you as the client want the asset to pass from your child to your grandchild, which again is our most common desired distribution pattern, where the client says, you know what, I want that to go to my son, but then when he dies, I want it to go to my grandson. I don't want it to go to my daughter-in-law or my son-in-law, regardless of how I feel about them. I may think they're great people, they're a great in-law, but the bottom line is I want my grandchildren to inherit those assets. And so that's what this inheritance protection trust does too, is it ensures a multi-generational legacy plan where the trust is automatically queued up so that it's for the child's benefit and full access by the child while they're alive. And then when they die, it goes down to the grandchild. And like I said, this trust is so protected that that child could go through a divorce and it'd be completely non-divisible. That child could go through a bankruptcy even, and all of the assets in this trust would be completely protected and preserved. So even for responsible people, they recognize that I could get divorced. I could have financial problems. I could, as a professional practitioner, face a malpractice suit. I could accidentally have a wrongful death and hit and kill someone, and then suddenly all my assets are exposed. And so the benefit of having the full value of the inheritance completely protected in perpetuity for multiple generations is something that is very attractive to clients, and oftentimes they don't realize that that's an option. So that's something that we very highly recommend, structuring inheritances in that manner, rather than just kicking the can to the next generation and just saying, well, yeah, just put it in your own name and then you deal with it, and whatever happens, happens. I mean, that's not planning, as you guys know. That's hoping. And so that's what our job as advisors is to help inform and educate about these different strategies. And this is simple as, just another added trust that all I got to do is tuck that inside of their revocable trust. It's a testamentary trust, and it's irrevocable. So it doesn't come into effect until those clients die. And that is when it comes in place. So it's not something that requires additional cost or maintenance throughout the client's lifetime. It's just sitting there in the background, waiting to come into effect at their death as that testamentary trust, at which point, like I said, it becomes irrevocable for the children to protect against all those risks, yet it puts up that wall to protect against the risks from the outside. Yet the client who's on the inside of those walls, they have full access to all of the money that's inside there for themselves and their own benefit, and again, the benefit of their family. So that's something that, again, we're very proactive on making sure people know that's an option, because once they do know it's an option, it's a very attractive option for many people who say, I've got that adult responsible child, but I do like the idea of multi-generational legacy planning. And I do like the idea of knowing that throughout that multi-generational legacy plan, my asset is going to be protected at both of those generations in perpetuity. So that's really the, again, it's not an estate tax strategy, it's not an income tax strategy, but it's really what we classify as a asset protection strategy of putting those assets into an inheritance protection trust for each of your adult children, so they would each inherit their own inheritance protection trust. So that's the main strategy that, as you saw, I wanted to go more in depth on today, is helping educate and inform about that, because I think that's a very strong one that many middle class and upper middle class Wisconsinites even, really like that strategy. And, obviously this isn't just a state of Wisconsin strategy. I just say that because that's largely the market of people that I work with. But, like I said, the hardworking Midwesterners who've worked hard and saved hard and said, you know what, I trust my kids because I raised them well. But at the same time, I like knowing that there is this backstop, that if anything ever goes wrong, it actually has that insurance or protection component to it that the trust provides. So that's the third bullet. And then just to wrap us up here at the end here with the special needs, again, I don't want to spend too much time on this. It's just a situation where whenever you have an individual who has special needs, and that's an important person in the client's plan, whether it's their grandchild or whether it's their child, it's very important to perform an assessment with them regarding what types of benefits may be received now or what might be anticipated to be received in the future. And then making sure that the trust is structured asset and income wise so as not to disqualify against any of those benefits. So that's the nice thing about the special needs trust, sometimes called a supplemental needs trust, is that you can still continue to receive the same government benefits for that beneficiary, but this can be a pot of money on the side that doesn't disqualify them from the benefits, but can give them some of those better quality of life items and some of those supplemental, not just needs, but things to take care of them, help them enjoy life more, that are going to be above and beyond what they might get from a standard government benefit. So that's something that's important. Again, special needs trust can actually be set up both ways. It can be set up as a living trust for the beneficiary while they're alive, if they're earning money and want to have somewhere to put money into. It can also be set up as a testamentary trust, where the mom and dad say, well, I know that my child or grandchild has special needs, and so I want to make sure that those needs will be properly taken care of, but at the same time not disqualifying my child or grandchild from any benefits. And so that would be, again, a trust that they'd set up for the future to be the beneficiary of assets, so that at death it comes into effect, but it's not in effect during lifetime. So again, even when you're talking about a special needs trust, it can exist in both of those realms. So it's important to figure out what the goal of the trust is, and what the clients and their loved one who has the special need, what they're trying to accomplish. So that covers for today what I wanted to do as far as introducing trusts and how they work, talking about some of the mid-level trust strategies before we get into the more technical high-level ones next week. So I always close my presentation with this. Thank you very much for spending your time to listen to me. I know this can sometimes be a dry topic. I try to keep it dynamic because it's something I'm very passionate about, and I love having the opportunity to speak with all of you and address you on this. I like to also extend that beyond just today's presentation, so that if you need a resource, and I know many of you are connected with great companies who have great resources of all these things within your company, but sometimes you say, you know what, I want to talk to a local practicing attorney who actually knows how this might roll out and how this particular situation might work for a particular client. My door is always open for that. You will never be charged for that. Feel free to just call me directly and say, I want to tell you a client situation. If you want it to be anonymous and not give the client name, that's perfectly fine. I always like to be here as a resource to financial advisors, especially those who I've worked with, those who have seen me present, and say, you know what, it's nice having a local attorney that I can turn to just for some simple client questions, because at the end of the day, I believe very much in the rising water, the rising tide, that, you know, we as financial and legal professionals should all help each other. And by doing so, we're going to do the most good for the most people. And we're going to really protect and do good for our clients by keeping open communication, by being accessible, by working as a team. And so again, those are some of our core values and core attributes that whenever we're working with other financial professionals, we really want to ensure that we're doing that. So that's kind of what I wanted to do to close here. Yeah, Abby?
Yes.
Yes.
Thanks, Eric. Great share. And thank you for sharing your knowledge. I'm over here taking copious notes. We do have a question from the audience. Does the current tax environment make trusts less important from a tax perspective than they were maybe 10 or more years ago? An example, most clients don't have 11 million or more in assets.
That is a fantastic question. So the question, I think in the question, there's some presumption that we're specifically talking about estate tax planning and using trust as a strategy to mitigate estate taxes. So that will be something, tune in next week. We'll be hearing more about that specifically. But to answer the question today, because I want to make sure you do get a good, clear answer, the answer is under the current law, keyword current law, I would say the answer is trusts under current law are less necessary for the sole purpose of mitigating estate taxes. Now, like I said, today we didn't talk specifically about estate taxes. We talked about other protection strategies, but yes, because you're dealing with an $11 million exemption, if you're utilizing a trust as a estate tax mitigation strategy, that type of trust and that type of goal is going to be lesser in demand right now, because simply the threshold for estates that are exposed to that is very high, which means that the number of estates that are exposed is very low. But that being said, again, the key thing that I've been keeping my ear to the ground on too is, you know, what kind of tax reform we can expect to see, number one, under the new administration that we have in Washington, but also number two, under sunsetting of provisions. So even the estate tax regime that we're currently under is going to be set to sunset in several years. And so it's going to be chopped again in half, so that it's going to be back to what we were more used to. Again, don't want to turn this into a whole ordeal on estate tax, but our belief and the belief of most commentators in our industry is that estate tax number should be somewhere between 3.5 million to 5 million, somewhere in that range. And we do think that that's likely where it's going to settle out long term. And so what that means is it is actually of concern for many of our clients, even, you know, upper middle class Midwesterners, because what's not known by some people is, especially married couples, for example, you do need to take proactive action in order to utilize both spouses' exemptions. That's one of my big pet peeves, is sometimes in financial and legal commentaries that I read, it makes it presume that you're automatically going to receive a double exemption for a married couple. And that's simply not true. We can maybe get into this more next time, but there is proactive actions even that you need to take to utilize and ensure that you get a double exemption. So long and short of it, I would say is that under our very current laws, the need is much less for estate tax mitigation because the number is so high. We do anticipate that number to come back down. And so we do think that trusts will use more of those strategies again in the future. What you were seeing us do 10 years ago, you'll see that again more in the future. But also, regardless of whether you have those estate tax mitigation needs, trusts are going to be essential to meet other needs in an estate plan, not just estate taxes.
Eric, Brendan here. First off, thank you too, I like how you tied in your presentation to the National Day with umbrella and the rain cloud and all that sort of stuff. So I just want to give you the heads up for next week. It's National Cabbage Day. So please try to integrate that.
All right.
But thank you.
All right. I will get to work on that. I'll have to think about that one. Is cabbage a metaphor for money or anything like that? I don't know.
Ah,
Could
hey.
be.
Bring in that cabbage. I don't.
Bring home the sauerkraut.
Okay, yeah, that's one that our viewers could relate to, I'm sure. The brats and the sauerkraut, man. But no, I'm inventing now. So, but no, thank you.
Yes, thank you for that question from the audience. That came from John Florence. Any other questions from the audience? You can unmute or send me a message. Hearing none. Eric, I'm going to have us do the drawing. If you could give me a number between 1 and 14. Okay.
Let's do number 12.
Number 12. Who's the winner? Who's the winner? And also, this presentation deck, as well as the recording of the brew, will be housed on the BREW blog. So if you want to rewatch, it's there for you. Okay, number 12. That is Kevin Christ. Congratulations, Kevin Christ. Be on the lookout for a complimentary CE course coming your way from all of us here at E4. And be sure to tune in next week. Eric will be back with the second part of Trusts Uncovered, highlighting ILETs and credit, shelter, and charitable trusts. Thanks for tuning in. Happy 2021 and have a great day.